Good evening, you're watching The Digital Age, and I'm James Goodale. Got a great show for you tonight with Anthony Lewis, known as Tony Lewis, who's the Pulitzer Prize winning author. And he's written a new book about freedom of the press. But you've heard so much about freedom of the press and how great it is. I thought I'd turn it around a little bit tonight and ask Tony, when should the First Amendment lose? It's not really as silly as it sounds, because in his book, he draws lines between when the First Amendment should win and when it shouldn't, and that's what really makes it interesting. Tony, thank you very much for coming by.
It's my pleasure.
I'm gonna, you don't know what's gonna happen next, right? I'm gonna show you your book. There we go. Freedom for the Thought We Hate. Great book. All of your books on the law have been great, and they're great not only for lawyers, but for non-lawyers too. Well, let's start off with a question to get the ball rolling here. Should Judy Miller have lost?
As the case was actually presented to the courts, the answer, I'm afraid, is yes. I say that with regret, because I don't like to see journalists go to jail, and the necessity to protect sources is undoubted. But she was, the facts in her case were very difficult from the point of view of prevailing. She wasn't protecting a whistleblower. She was protecting somebody in the government who was trying to smash a whistleblower. It was the opposite of the usual moral position.
You have written a whole chapter in this book on the reporter's privilege, and you have written in the past, and I think it'd be fair to say that you're not necessarily a fan of the reporter's privilege. And the reporter's privilege, by the way, means the ability of Judy Miller to take a privileged position with respect to her information and not turn it over. That's what she was arguing about, so-called reporter's privilege. Where are you on the reporter's privilege these days?
I am on that as on some other things, which you implied at the start. I think that the needs of journalists, and they are needs, I agree, sometimes have to be weighed against other needs in society. And for example, I find compelling somebody who is injured by a newspaper story that relies on unnamed sources to say that a man has committed a crime, or has beaten his wife, or has stolen money. And it's not true. And the subject of the story, who's been vilified, wants to recover some damages and clear his name. And he sues, and of course he needs to find out who the source was. And the reporter won't say. I think that's a very difficult case to maintain that there is a moral cast to the reporter's privilege, because you're actually asking for a license to smear people without recourse, and I don't believe in that.
Well, you point out in your book, in that case, you could say to the jury, ladies and gentlemen of the jury, we know that there's a source for this story because you read about it in the article about which we were talking, but don't pay any attention to it. Just proceed as though it didn't take place. Do you think that would balance the fairness? In other words, I'm asking a larger question. Are there ways around your objections?
Ways to deal with it without sending reporters to jail? Yes, I think there are. That's one. You simply tell the jury to assume that there was no source. I don't think your solution would be very popular with newspapers because they would lose a lot of cases on that basis. But it is a possibility. And some judges have ordered it, have done that.
And as a practical matter, the newspaper would be required in such a situation to always have two people to get up and say what happened, because if the first one isn't going to say anything, you better have a fallback.
That's absolutely right. And if I were a lawyer and advising a newspaper on that kind of story, where a newspaper proposes to print a pejorative story about an individual, I would say you better have some source who's going to take the witness stand.
George Bush has said many things, but one of them has been...
How true?
One of them has been that if a journalist's privilege law, which is called a shield law, comes to his desk, he's going to veto it. And I don't think he's talking about any particular law, but he's just going to veto it.
Correct.
Would you do the same thing if you were George Bush?
No.
You wouldn't. So you're in favor of the reporter's privilege in some respects?
Yes, but the law as it's currently phrased in Congress is not an absolute privilege. It has numerous exceptions.
Okay, let me just stop you there, because
Sure.
What does an absolute privilege mean?
Absolute privilege means you can't make the journalist talk, no matter what the interest is on the other side. The smeared individual that I mentioned a moment ago, national security, whatever the interest is, it doesn't matter, the reporter can't be made to talk. That's an absolute privilege. A qualified privilege is when there's a privilege unless there's a national security interest or somebody's smeared or, you know, A, B, C, D.
Well, let me ask you about the New York Times publication of information about phone taps, so forth and so on, that has led to a lot of difficulty, including a subpoena issued to a New York Times reporter named Risen.
Jim Risen.
Jim Risen. Do you know him?
Met him, just met him. I don't really know.
A great investigative reporter.
Wonderful, wonderful.
What's current now is that he has to go before a grand jury and give up a source with respect to those stories. The catch is that the part of the story that is being sought wasn't published in the New York Times.
No, it was published in his book.
In his book, but it doesn't make any difference, I wouldn't have thought, in terms of this conversation. Where do you come out on that one? Because you just said before I talked about Risen, that there's a national security exception.
No, I wouldn't have a blanket national security exception because that exception would eat up the rule. I'm in favor of a qualified privilege that would balance those interests and allow a judge to decide which was more important. And in this case, the question is, was it more important to keep the secret, which is the government's position, or was it more important for the people of this country to know that the President of the United States had unlawfully, in violation of a criminal law, ordered his minions to wiretap on Americans' telephones? To me, that's an easy question. It was more important to bring out that fact. And so in my view of how it should work, there's no way of forcing Jim Risen to disclose his sources.
Now, let's go back to Judy Miller's case for a moment, because among the many pieces of information she didn't want to turn up and talk about was the fact that she'd been leaked a national intelligence estimate. And the national intelligence estimate related to the action by Congress in authorizing the president to in turn take action against Iraq. And that national intelligence estimate is a very important document in American history. It's the document, by the way, Hillary Clinton has said she never read.
Right.
And it was kept secret for a long time. And then when it was made public, only parts of it were made public. And she was given part of the material that was still private, still classified. Is that worth protecting, keeping in mind that it's very difficult for reporters to cover national security without dealing with classified information?
Well, I think it's entirely wrong of the government to press Judy Miller for her source on that document. I haven't thought through whether it should be protected in court. It's a close question, I think, a difficult question. But the government is much too free in throwing its weight around and trying to put reporters in jail for doing the job of covering national security. You know, there's too much secret in this country as it is. Presidents use immense powers. They claim immense powers, which they may or may not have legally. And if we're going to cover what they're doing, you're going to get into national security material, or what the government has defined as national security material.
Well, you have a chance to sum up, but I'll sum up a little bit by saying that with respect to reporters' privilege, there are some cases, such as the Judy Miller unadorned with the national security point. First Amendment should lose. Is that a fair way to sum up your position?
I hate to put it in terms of the First Amendment losing, because I don't think the First Amendment is absolute. I don't think it's a question of the First Amendment losing. I think it's a question of some other interest prevailing.
Okay. Recently, the net has been hit with a spate of suicides. One such suicide case took place in Chicago, where the head of an advertising agency had been flamed on the net, which means that there were terrible things said about him. He thereafter committed suicide. No one knows whether it's a direct connection, but it certainly raises the question of whether he did commit suicide because of what was said about him. In another instance, in a Facebook situation, a teenager, 13 years old, was harassed on the net by a next-door neighbor's mother, if you can believe it.
Yes.
And her compatriots. and they said terrible things about her and left a message. The last one she got, the world would be better off without you. And she walked upstairs and she committed suicide. Now, in your book, there are two interesting examples of roughly parallel stuff where people's privacy have been invaded. One was a 11-year-old child genius who went to Harvard at age 11,
yes,
and who was found dead under uncertain circumstances in the north end of Boston, and his career had gone nowhere. In fact, he was reading railroad transfer sheets. You can tell me exactly what that was. And then there's another case which Richard Nixon argued on the Desperate Hours, which was a story of a woman who had whose house had been invaded by robbers, and she'd been held hostage. Case went to Supreme Court. She lost. Sidus lost his case too. Thereafter, I believe you said she committed, not thereafter, but later on,
well,
she committed suicide.
A year or two later, she committed suicide.
So,
and she was a woman who tremendously valued her privacy. She moved from the home where she lived when this episode with the robbers occurred to a remote location to get away from the press. And then Life magazine nevertheless published a story, and she took it very hard. And psychiatrists had warned that she was in a very fragile condition, and she committed suicide.
Now, these are two cases in your where the First Amendment won.
Yes.
First Amendment won. Nixon was on the other side. He lost. Nixon
Yes.
lost that case. It was his only case in the Supreme Court. Is that right?
I think so. And he told his law partner, Leonard Garment, that he knew they would never let him win a case.
The Supreme Court would never let him win.
Yes.
Never let him win a
But
prize.
he came very close, 5-4.
And the Sidus case would never went to the Supreme Court, but Sidus lost that case. So just to put this...
Sidus was the boy genius who turned his back on geniusdom.
Right. Okay, so these are two cases where the First Amendment won, but the way I read your book, I know you don't like me to say it this way, you think the First Amendment should have lost.
I don't mind your saying it that way in those two cases, because I thought the claims of privacy were rather strong in both cases. Indeed, the judge who decided the Sidus case, a much earlier case, Charles Clark of the United States Court of Appeals for the Second Circuit, described what had been done to Sidus in this article written about him years later under the heading of Where Are They Now? This forgotten boy genius, and it painted him in what Judge Clark called pitiful terms or pitiable terms, mocking him and really giving him a very mean, nasty time. And I thought that all he sought was some modest damages for invasion of his privacy, and I thought I thought he deserved compensation. And Mrs. Hill, the claim of Life magazine was that it was entitled to fudge the facts of the case and transmute them into something more sensational. And they sensationalized that to the personal destruction of Mrs. Hill. And I thought, you know, the Hill family had won $25,000 as an award in the lower court. That's pretty trivial, and that was all that was involved.
There is a large question, particularly with the net, as to privacy. And wrapped up in that question is whether you should penalize in some fashion, whether it be $25,000 or something else, the publication of truth.
Yes.
Truthful facts that are embarrassing are the types of cases we've been talking about, the two net cases and the two that you've talked about. And many First Amendment types think that there should be an absolute protection for the publication of truth. What do you think about that point of view?
No, I don't think there should be an absolute protection for publication of truth, because sometimes truth is so private and so invasive that it's wrong to publish it. May I give you another example?
Yep, sure.
Do I have time?
Yeah.
This is a case from California where a woman was driving a car on a freeway, and the car went off the freeway, rolled down a hill. She was badly injured. In fact, she emerged a paraplegic. A rescue helicopter came, took her into the helicopter, and as she moaned and cried in her pain, there was a nurse on the helicopter. Unknown to the woman, the nurse had a hidden camera and microphone and was recording her cries of pain. And she sued for invasion of privacy. And the California Supreme Court held that she was entitled to maintain a suit for for the actual invasion of her privacy. And I thought it was right that she should be able to recover those damages. What interest is, what public interest is there in showing a woman in agony in a rescue helicopter? I can't find any public interest whatever.
I guess the problem is where do you draw the line? Which is,
well, that's what judges do. They draw lines all the time.
That's what this book is about. But you want to give guidance to judges, right?
Yes.
We might point out to the audience that Tony Lewis is here having an argument with lawyer Goodale, but he's not a lawyer.
That's true.
Yeah, so you're being a good sport about this. But as you well know, you'll have to come up with some sort of formulation to draw the lines. And that's what your book is really in some part about that. I don't want to say large part because it's as much as anything about judges. But how would you articulate one situation from another where you can publish truth with respect to private information, but you can't others?
Well, there isn't any precise formula that will solve all problems. That's why we have judges. They have to weigh up the facts in every case and decide which side wins. In the case of the woman who was injured and going off the expressway in California, I'd say that the judges weighed, and they wrote very learned opinions, actually, to me, very persuasive opinions. It was clear that the interest of the public in seeing this woman in agony in a rescue helicopter was rather modest, and that her interest in not having her agony portrayed before the public was rather substantial, and that it was an invasion. Invasion, the public said, because the cameras went into a place where they could not be expected to be. You had a reasonable expectation of privacy. If you flaunt yourself on the public street, you walk naked down Beverly Hills Boulevard or whatever it's called, Sunset Boulevard, then you're not expecting privacy. You're walking in a public place, but when you're inside a rescue helicopter, you have a reasonable expectation of privacy.
One has a reasonable expectation of privacy within one's bedroom, and if one is walking around without any clothes on, one would not hope to be seen in that fashion anywhere in the press.
Correct.
But what's interesting about the internet age is that while you and I have a particular reaction to that statement I just made, the internet generation doesn't seem to be as concerned about privacy. They send nude pictures of each other over the net.
It's an absolutely amazing phenomenon to me. Not the nude pictures so much as the complete lack of interest in privacy in any respect. People list their favorite friends, their least favorite friends, you know, things that you would think you wouldn't want to parade because the consequences might be so nasty or so out of line. People just want to let it all hang out. Well, I didn't want to let anything hang out.
Do you think this is generational then?
Oh, yes, I do.
Well, then, I suppose the question comes up, since the Supreme Court has never decided the item we're talking about.
Correct.
What will the Supreme Court do? And in that connection, you live in Cambridge. Justice Breyer lives in Cambridge. Justice Breyer taught at the Harvard Law School. You taught at the Harvard Law School since you were allowed to do that, even though you weren't even a lawyer. Now, Justice Breyer is a very interesting person for a couple of reasons, but on this particular point, in a case that went up involving the receipt of information that went over telephone that was highly offensive. I don't want to go into any more of that, but when that case went up to the Supreme Court, it was a public case. Breyer said, well, okay on this case, but if it's private, I think all the rules will change. So if this type of case goes up before Breyer, what do you think he will do?
He would be on the side of the claim of privacy. So what you want to do, Jim, if you want to change this outlook, is to get some 20-year-olds appointed to the Supreme Court of the United States, because they're all now up now 70, 88 in the case of Justice Stevens, or he's about to have his 88th birthday. And so you're not going to get the new generation from them.
Well, you made your fame in some respects by covering the Supreme Court, I think it's fair to say. And in that coverage, we're cut a new corner, so to speak, in journalism, because no one really, before you, wrote with such lucidity about the court. So we all could understand it.
Thank you.
What do you think about this court, present court?
I think it's made a sharp turn to the right. Not so much in First Amendment cases. They've had one First Amendment case of not very broad interest, but on abortion and on a number of other issues. We've just had the death penalty case, where again I think that's relevant. It's not decisive, but the appointments made by President Bush have moved the court sharply to the right, especially the replacement of Justice Sandra Day O'Connor, who was you might call her a centrist figure.
Did you like her as a justice?
Yes, I did, yes.
Excuse me for interrupting, but who was your favorite justice?
Now?
No, well, let's see. It's a relevant question. I have to tell the audience a relevant question because this book starts way back then, at the beginning of the 20th century. All right, now.
Do I get to?
Yeah.
Oh, now?
Now.
In the past, but I don't know, I wouldn't pick a favorite, but the most interesting was Justice Black, who came out of this populist background in Alabama, a Southern senator, very radical in his views, a great supporter of the New Deal, appointed by President Roosevelt to the Supreme Court, and really believed, like you, almost like you,
well,
in absolute freedom of speech.
Do I get a chance?
Yeah.
Yeah, but how could you like him? Because you don't.
Oh, I don't say, people don't always have to agree with me 100%. Nobody could resist the wonderful passion of Hugo Black, you know, who said in the Pentagon Papers case that the most profound obligation of the press was to uncover the secrets of government, especially when the government sends our people overseas to die of foreign fevers and foreign shot and shell. He said that in the Pentagon Papers case in 1971, but it's extremely apt today.
Yeah, I get the reference. Your favorite justice presently?
Oh, I wouldn't want to say that.
You wouldn't? Why not? You're not recovering the...
Well, I might meet one of them. And, well, I'm not your favorite?
Your favorite justice of all time, reading through the book here? Justice Holmes.
Holmes or Brandeis. Different, but both passionate admirers of the First Amendment, and they reshaped it into modern form.
Let's go back to Breyer for a moment. Is it true that he said to you, after his first term on the court, Tony, do you know any good First Amendment summer seminar courses? And you said to him, I find that a very strange question to answer, Mr. Justice. And he said, I'm asking because I've decided I don't know anything about the First Amendment. Did that happen?
It's a great story, but I don't remember it. It might have happened, but I honestly don't remember.
Let's pick up Breyer with respect to a case that's just gone to the Supreme Court. I'm talking about the case on, I want to say obscenity, but it isn't. It's indecency and it's profanity, really. Okay? And this case involves the use of language that was used in the Private Ryan case, where the F and S words were used. In fact, the facts that take this case to the Supreme Court are from a television broadcast where the F and S word were used. A couple of questions. The court hasn't dealt with this issue for at least 30 years. Why do you think the court took this case?
Probably because a majority of the court, or enough members of the court, with the Bush appointees, really take a puritanical view of what can be on television. I mean, that's my guess. Because I regard it as preposterous. You know, in the course of a program that wasn't scripted, it wasn't written in a script, it was an extemporary.
It's fleeting.
Yeah, it was a live program, and whoever the person was just slipped a four-letter word into a stream of consciousness. And how was the broadcaster even to know it was coming? It was, you know, to punish the broadcaster for something like that seems to me absurd.
Now, can we count heads here? Because it's fun to talk about the court. And let's start with Breyer. Breyer has an interesting history with respect to soft porn language and soft porn. And he's voted against, if I may say so, the First Amendment in almost every case he's had. And indeed, the last case that went up there, he voted against the First Amendment, and Justice Thomas voted for the First Amendment. That's in the COPA case, anyway, FYI.
Yeah.
Okay, so if Breyer, how do you think Breyer will vote on this?
I never have a real idea of how anybody's going to vote. But I mean, Stephen Breyer is a sophisticated man. He's not a doctrinaire First Amendment supporter. You're absolutely right. He hasn't been a solid supporter of First Amendment issues. But I can't believe he's going to allow punishment of a broadcaster for a casual slipping of a four-letter word into an extemporaneous broadcast. It's too silly, I think. I may be proved wrong pretty soon.
With O'Connor gone, and you said she was one of your favorite, well, you liked her, I should say. There may not be a lot of votes for the First Amendment. If Breyer, let's say, put a question mark next to Breyer, where are the votes now for the First Amendment, would you think? Because she, let me just make it clear that she was with a fifth vote frequently on First Amendment cases.
Absolutely.
And there's no fifth vote there anymore.
It's hard to count them up. I agree with the implication of your question. But on basic First Amendment questions, the right of free speech on political issues, the court is not divided. They'd all be for the right of free speech on political questions. This is a more marginal question, the indecency. On that, some members of the court will undoubtedly want to give the Federal Communications Commission room to play nanny to the country, which is what it wants to do. I think it's, as I said, ridiculous, but that's what they want to do. And because they're more statist, some members of the court simply are prepared to approve whatever the federal government does, and I'm very dubious of that.
Well, we've come to the end, and so you're supposed to tell me, when should the First Amendment lose? And the answer to that question is when?
When the interests on the other side are overwhelming, the social interests, and that doesn't happen often, but it does happen occasionally.
Thank you, Tony Lewis, for coming by.
Thank you, Jim.
And thank you for coming by. And come by next week and learn more about the digital age. For the digital age, I am James Goodale. Good night and have a good week.